This is our final panel for today, the first day. And it sort of, I guess, follows up on some of the lunchtime speakers topics. But we're going to look at the FTC proposals on non-compete agreements. And our speakers are Erica Ozer, to my immediate left. Here's Senior Vice President, CBRE. Next is Taylor Owings from Baker Botts. And then Mark Risk from Mark Risk PC. And the commentators are going to be on far left, I guess, Amy Schulman, Alton and Golden, and Amy Traub with the Baker Hostetler.
Thanks, Jim. So we are the two Amy's, the commentators on this panel. And we heard from Elizabeth Wilkins at the lunchtime presentation on the FTC proposed rules regarding non-competes. That is our topic. We saw all the interest across the room at lunchtime. What we plan to do, the two Amy's, is we are going to do kind of a firestorm of questions on our esteemed panelists here, hoping to capture all the things that are on your mind. But we look forward to the last few minutes of our presentation to the extent we don't cover something that you'd like to ask about. So, Amy?
Good afternoon, everybody. Thanks so much for being here and listening to us. So I'm sure you're all familiar with the FTC's proposed rule banning non-competes. I think just in time for our session, the comment period on the proposed rule ended. Thank you, Sam, for arranging that timing. So we'd like to start off by asking our panelists, what is the impetus for the FTC's decision to propose this rule? What are the economic and social and political factors that have led to this point? And it seems that there has been some groundswell of state action on this topic recently. Is that related? And kind of how did we get to this point? Mark and Taylor, if you want to start off.
Well, I don't know. I did take note that, was it 5 or 10 years ago, the topic of non-competes made the front page of the New York Times 3 times. They did a series about them, and that's not the normal place you'd see an employment law doctrinal problem. And the part of the cast of that, or the pitch of those articles, was about the extent to which they're being used on lower wage workers and the notion that they're anti-competitive. And I think that's been percolating around, and that's certainly what the FTC thinks. When you agree to be on a panel on the FTC rule, and then you print a copy, it's 180 pages. The last 2 pages of which are the actual rule, and the first 178 pages are a somewhat scholarly analysis of the anti-competitive effect of non-competes. I'll stop there except to say, since we're in a scholarly setting, to me the interesting political, social, intellectual issue is, well, let me preface it by saying there's a similar, the FTC proposal, as I understand it, is basically law in Ontario province, one of the 9 provinces of Canada, and a major province that includes the city of Toronto. Last week, or 2 weeks ago, the conservative government in Ontario, last week, the Conservative government in the UK announced that it is seeking legislation from the Parliament to severely restrict non-competes. So the intellectual question for me is, how does it happen that other than here, conservative governments are proposing these restrictions?
So I think it's important to put the rule in context going back to at least 2016. And let me actually start by a quick disclaimer here that I am the token antitrust lawyer here. So I'm bringing the competition law, the administrative law as it applies to the FTC perspective, but I am here to listen as it, with respect to labor and employment and the history of these cases in states and the legislative debate on them. However, looking at the groundswell of support in antitrust law for the application of those principles to labor markets. That's longstanding. That's going back to 2016 when the FTC and the DOJ issued a joint statement clarifying that no-poach agreements and wage-fixing agreements would be treated as criminal offenses under the Sherman Act, and the number of cases that the DOJ brought during the Trump administration to realize that principle that was announced in 2016, and the many policy speeches reiterating the fact that labor markets are markets just like any other that the antitrust laws apply to. That's a cohesive principle all the way through both the Obama and Trump administrations. And then you see the Biden administration come in and reinvigorate this concept, but broaden it out to include this idea of non-competes being an offense under the antitrust laws. I think the other point of context that's important to consider when considering this rule is that it was a known policy priority of now Chair Lina Khan, Chair of the FTC, Lina Khan, to do a competition-based rulemaking. This is a point of scholarly interest of hers. She has an academic piece from before she joined the FTC advocating for rulemaking being an unused and important policy tool that the FTC should take up and use to bring clarity to the rules that businesses ought to follow. And I think you heard that theme from Ms. Wilkins at lunch, that one thing that the FTC is really striving to do with this rule is clarify, rather than have an uncertain question of when companies can use non-competes. They're looking to make it very clear by banning them altogether.
Great. So let's talk a little bit about the scope of this proposed rule. And I'm an employer side lawyer, so there are certain things that are certainly on my clients' minds. So one is, does the scope extend beyond clauses that explicitly prohibit competition? So for example, a forfeiture for competition provision, or a provision that requires the forfeiture of deferred comp if the employee engages in prohibited competition without an outright prohibition on competition. And of course, just about every employer probably wants to know whether a garden leave provision would survive FTC scrutiny under the proposed rules. And are there certain types of garden leave that you think would survive scrutiny and others that would not?
Yeah, so let me take the first part of this. And the way it's written in the proposal is that it's anything that de facto operates as a non-compete. And that's a very, very broad statement if you think about that. And to your point about forfeiture clauses and some of the other examples that are in the proposed rules, it actually could be a non-disclosure agreement that somehow has a de facto, ends up operating as a non-compete. It also could include, they gave an example of training agreements that have where the company's going to pay for your training costs, and it includes a clawback. That could actually, that's an example that's given in the proposed regs as they are right now. Liquidated damages could even be some sort of non-solicitation of clients, where the maybe in the sales context, where a salesperson really can't de facto work anywhere else because they rely on the relationships they have with those clients. Recruiting agreement, non-solicitation of employees somehow could also end up that way. So I do think it's extremely broad.
Yeah, I think it covers any arrangement that prohibits post-employment competition, and I think it doesn't care what the remedy is. So I agree that it's broad. As to one of the 26,000 comments to the FTC is from me. I like to think one of the more readable ones, and I think garden leave is the soft spot in this, because strictly speaking, garden leave is not a restriction on post-termination activity, right? And garden leave, for you traditional labor lawyers in the room, right? It's a paid pre-termination notice period. So I think insofar as it the restricted party is still an employee, it's technically not covered by the proposal, and so I wrote to the FTC that they ought to include that among those clauses that could function as a non-compete.
I'll just chime in and offer that this, exactly what Mark's talking about, is the reason to have notice and comment rulemaking, right? It starts with a proposed rule, and then you get feedback from interested parties and the lawyers who do this every day, as well as the people affected by this every day. And they raise issues like garden leave. Like, we don't know what your rule is saying about garden leave, and I wouldn't be surprised to see that a transition from proposed rule to final rule may address that. When you look for clues about the way the FTC might feel about garden leave, you go into the justification and the meat of the explanation for what they're doing in the proposed rule. You see that they have two major categories of justification. One is that workers are exploited by non-compete agreements. So that one, you think maybe garden leave doesn't apply so much, right? If you're getting paid and it's a quid pro quo rather than an exploitative arrangement, maybe garden leave isn't a good match for fixing that exploitation problem. But secondly, as it applies to higher wage workers, not just low wage workers, the FTC describes that it wants labor to be free to go to competing businesses so that downstream competitors in the final product markets can get labor to come to them and usefully compete in that downstream market. That is a place where garden leave would prevent that labor from flowing downstream and creating competition downstream.
Thanks, Taylor. So let's imagine that the proposed rule in its current form, or something close to it, is issued. The FTC issues regulations in the CFR banning non-competes and de facto non-competes. We have state laws that, we have several states that, I think there are 3 that completely ban non-competes. The New York State Senate is actually conducting a public hearing today on a proposed law to ban non-competes, and there are states that ban non-competes to some extent and others that don't have bans at all. What is someone to do if they think they have a non-compete that's banned by, or a clause that's banned by the FTC's rule? Who can bring a case challenging it? How is the rule, if it's issued, going to be enforced? Taylor, and what happens to the state laws that are on the books already?
Yeah, so this is not an obvious answer, and I think one of the questions that, again, is being raised in lots of the comments that you see filed to the rulemaking. I think the simplest answer is to look at the text of the FTC Act and to see what it allows the FTC to do. We're going to talk in a minute about whether competition rulemaking is even delegated to the FTC at all, and I have serious concerns that it's not. But assuming for a second that it is, how would, what bite would such a rule have? Well, it's clear that in the consumer protection context, when a rule is passed, there's statutory provisions allowing the FTC to collect fines against companies who are violating a rule. It's pretty clear that that power is nowhere contemplated in the section of the FTC Act that the FTC is using to do this rulemaking. So this Section 6G rulemaking, for those really deep in the citations here. Section 6G is what they cite that they're using, and it says nothing about remedies. The Supreme Court decided last year in AMG that the FTC cannot collect monetary relief by sort of reading between the lines of its power, calling it sort of, equitable powers to collect restitution or something else. So that means the FTC is really cabined in what it can do to bring an action against a company that is offending its rule in this competition context. Arguably, it's going to look really similar to what they can do today. They can bring an enforcement action for injunctive relief against a company that's doing something that's an unfair method of competition. The only difference is they will have predefined that non-competes and employment agreements are an unfair competition, and so are an unfair method of competition, and so the enforcement action will proceed much quicker. Of course, it's a little bit anybody's guess how the general sort of policy point of the FTC banning these things and calling them unfair methods of competition is going to trickle down to applicable state law disputes. I think you'd have a great argument that a provision is void for public policy in any employment agreement that is being fought or adjudicated. Many states have little FTC acts that may allow for private rights of action or may allow state attorneys general to seek those fines under state law, saying, hey, this is an unfair method of competition. We know because the FTC told us so, but then our own state legislature gave me, the AG, the ability to collect fines and monetary damages on behalf of consumers in state court.
And this has been an unusually humbling panel preparation for me. Not that they aren't always, but I live in a different world as to this rule than Taylor does. A client comes to me and says, I have this great new job, but I work at Erica's company and they have a non-compete. I have a non-compete, and I just had lunch with my business school classmate who says, nobody ever worries about these. That's the fact pattern that gets presented to me. And I thought the FTC rule was going to solve that, and now I've learned, we've had some calls with Taylor, I've gone back and actually read the statute, and there's no private cause of action. So it's not clear what the FTC rule, even if made into law, even if the final rule is approved exactly as is, it's not clear what that would mean for me if I'm down at 60 Center Street with a client saying to a state court judge, this non-compete should be thrown out, the FTC says so.
So Mark, given that there may not be a private enforcement mechanism in practical terms, and as many of us who represent employees know, even if there were, it's often very difficult financially, professionally, for an employee to go to court to challenge an overly broad non-compete clause to begin with. Mark, what incentive, if any, and Erica and Taylor, please feel free to weigh in, what, if any, incentive is there for companies to draft reasonable, narrowly tailored non-competes in the first place? Are there any checks and balances in the system?
Well, right now, if you draft an unreasonably broad one, then you could suffer under the Sherman Act, which gives treble damages and does have a private cause of action. So an unreasonably broad non-compete is quite a third rail. What we're talking about here with this, that's the law today, right? There are plenty of private treble damages, actions, claims going on at any given time throughout the country for unreasonably broad non-competes. This rule would purport to create a per se ban on all non-competes, not just those that are unreasonably broad in geography and time.
But there's a parallel contract law approach, which, it's old and it's common law and it's everywhere, and it's here and it's in England, that the New York way of saying it is at least theoretically, the restriction is disfavored and enforced only to the extent reasonably necessary to protect legitimate rather than illegitimate interests. My view is the application of that is not stringent enough. And to pick my favorite example, in New York we have a blue pencil rule that the court will, unless it's really intentionally overbroad, the court will simply modify it and reduce it to be lawful. And I believe this takes away a lot of the incentive on employers to do what they should do, which everyone tells them to do, which is decide the non-compete you really need and draft it narrowly as to scope and duration.
Well, I'm going to dispute what you just said. Take the employer side to this. I do think there's some thought process that goes into this in terms of, because if you were just to give a blanket 2-year non-compete to every single employee that works for you, who's going to work for you? I mean, the market isn't that bad that, if you want to be an employer of choice, I don't think you could do that lightly. But secondly, I think you have to decide that you're going to pick the ones that you would actually enforce if you needed to, because you're not going to go and enforce 100,000 non-competes against your employees. So you really should be thoughtful about where you need to use them, if at all.
But I find for a lot of employers, that decision is made not at the date of hire, but at the date of termination. That is to say, it's drafted broadly, and probably at the date of termination of the relationship, there's no issue. But if the employer needs it, it uses it, and it can have more confidence in its 2-year restriction than I think it ought to, because it knows the judge will just cut that to 1 year if it's
If you're
deemed to
in a
be
blue
broad.
pencil
That's
state.
my issue with the blue pencil
Yeah.
rule.
So the rationale frequently cited for non-competes is the need to protect confidential information and trade secrets. Are there other avenues of protecting confidential information and trade secrets, and why not are those other avenues sufficient? Particularly, as we're staring down the barrel of this proposed rule, what are employers thinking about doing? What are you advising clients to do?
Yeah. I think there are some other avenues, and again, it's not one size fits all. It really has to be thought through that these are the real situations where I need a non-compete. So, you could think about non-disclosure agreements, you could think about non-solicitation of clients and employees. That can be very helpful tools, and for most situations, those will work. But there are some situations where I think it's not just about the information that you're trying to protect. It's something more than that. So whether it's a little bit of a know-how, I'll give you some examples. A very high-level executive who is just intimately involved in all of the strategy of the company. Okay, that's something where if that person was to go to your biggest, fiercest competitor, there's more than just the confidential information that person knows that you might want to protect. I would say also maybe someone who is deeply, deeply steeped in R&D, the person who knows that formula to Coca-Cola, you're not going to want them to go to Pepsi, right? That would be an example. I think some other examples would be where you've done, serious investment in training, I think about the sales context, where somebody has really learned either from almost like an apprenticeship program within your organization and has built these deep relationships. And now it's not necessarily it's all of that investment, it's everything that now you're just handing over to a competitor that you might want to protect, and that a non-disclosure agreement or a non-solicitation is not going to do that. And then the final one, to go back to something that Amy brought up earlier, is actually retirees, or people who say they're going to be retiring and are going to get better benefits, whether it's equity or something like that. Employers may want to make sure that person is going to truly retire from the business if they're going to collect all those better benefits. So those would just be some examples.
I'll also raise what I've heard a lot of employers tell me in discussing this rule and the potential implications for it, and some of the real world facts that the FTC should know about before they promulgate a final version of this rule. And it's about the difficulty of detection of the sharing of competitively sensitive information. So you can have an NDA in place, but it's quite another thing to try to discover whether the employee disclosed the information and then that information was utilized by your closest competitor to get an edge on you. Other times, this is just sort of contracting 101, it can be very difficult to reduce to terms what is the thing you can't disclose, right? If you are a senior executive and there's sort of a general ethos of strategy of where the company is going to go to try to outfox its closest competitor. Someone might truly be hired to give that closest competitor an edge on that strategy type decision making that isn't, don't disclose the recipe to Coke, right? That's easy to reduce to a contract, but some other higher level information sharing about direction and strategy is really hard to reduce to contract terms. And this is all before we even get to the problem of time and length and uncertainty of litigation, right? This is even just detecting it from the beginning or writing it into the contract from the beginning. Of course, everyone in this room is well aware that the time and the expense of litigation is, and the uncertainty of whether you're really going to be able to enforce the rights around that competitively sensitive information creates a real cost that this rule would be embracing by saying you have to use those methods rather than non-competes.
Taylor's made the point that employers are making that's compelling, that I've had to think about, which is a lawsuit for theft of confidential information isn't really effective because we'll never know, we'll never be able to prove it, and therefore we need the blanket non-compete. And I would only add to that we already have that jurisprudence. That's the jurisprudence of inevitable disclosure. That I'm entitled to a restriction, not because you took my information, but because it's inevitable that you will. And that, in New York, that's a very high standard. And so I think the answer to this employer argument is, at least under current law, we've really already answered it, which with sorry, you have to prove it. Now, on the executives, I should say my friend, Amy Schulman, hasn't told you she's led a national, is it a task force, Amy, in the plaintiff's bar to submit a beautiful and extensive set of comments to the FTC about that, against which my own suddenly looked much more modest.
You mean readable, right?
Amy's task force really wanted the new rule enforced, and I was I think it's fair to say the FTC says about senior executives, or the group of people you management people call C-suite executives. I never really understood what that meant. That the FTC sort of says, write to us about senior executives. We're wondering if the rule should. That's an area we want to know more about. And I'll say, since we're in an intimate gathering, that from my own practice, I'm much less concerned about senior executives because they're paid more money and have more leverage, and because they really do, they are closer to the sun. They do have more access. And if they're hired by a competitor and there's going to be a fight, in my anecdotal experience, it's much more likely, and this is an ideal situation for me as a sole practitioner litigating for employees, the executive says, my new employer, giant company, is prepared to fight this with an unlimited budget and just send my bills to them, Mark. And so I get to I get to litigate fully for an individual without a collection concern. When a middle management person comes in, simply trying to better their life for their family, I say to them, the most important person in the conversation is your new employer. Are they gonna cut and run when a lawyer's letter appears? Or are they gonna stay in here with you? And the truth is, for a middle management person, the employer is much more likely to say, gee, we'd really love to hire you, but not if I'm taking on a litigation on day one. So to me, the case is much more compelling for people down the chain a little bit.
Yeah, I thank you, Mark. I would just add to that. I mean, I think with respect to confidentiality, from my perspective, I mean, if anyone's in a position to figure out where confidential information has gone and what's happened to it, it seems to be employers. I mean, we have employers tracking when people leave their buildings through, key scans and worrying about people who are gone more than others, looking for new jobs. There are so many aspects of employee movement that are tracked online and that are monitored. It seems to be that employers have a lot of information to be able to, keep track of their information. I mean, I also think that when you're talking about senior executives, it's kind of a very amorphous category, because a lot of times when somebody is, asking for something from their employer, they're told it's only for senior executives, and when they're talking about a non-compete, suddenly they're senior executives for the purposes of the non-compete. So I'm not saying all companies, but I'm saying a lot of times that's kind of the conversation that tends to happen. But Mark, I mean, it's in terms of the legislation that's come up around non-competes, there seem to have been some strange bedfellows, because as you mentioned before, there were conservative governments in Ontario that have issued rules on non-competes or ban non-competes. Mark told us about recent legislation or proposed legislation in the UK being undertaken by a conservative government. What do you think accounts for this, and kind of how do you see this playing out in similar jurisdictions around the world?
Well, let me try to throw a long pass here, since we're in an academic setting, and say that we've all said to each other for years, non-compete litigation is unique in employment litigation because it's the only area in which you could be, we all work both sides. Or certainly on the employer side bar, you're either the hiring employer or you're the we'll call a former employer. I think these conservative initiatives suggest that we ought to take a closer look at that. And I'm told by my friends in the UK that the context there is, we have a new government, conservative government. We're now out of Europe, and we're gonna stand for competitiveness here. And it's an interest in competitiveness that's brought about this result. And so I think there's a growing distinction between the kinds of employers, older established employers and what my business friends call disruptor employers, or new economy employers, that maybe conservative governments have concluded that non-compete doctrine is, and I think it's ossified. The restrictions are too heavy and too difficult for people. In the current body of law, which is, in New York, is really just the common law extended, 100 years later. It's the same concept.
So sticking with other jurisdictions, let's talk about California for a few minutes. We certainly see some of what we've got in this proposed rule having already borne forth in California. So does it provide an apt case for us to see where things could be in this new world?
Yeah, so I mean, I would say yes and no. So I think it's working well in some areas. I mean, if you think about it, California is also the home of Silicon Valley, and as Mark was mentioning, those disruptor companies that really do rely on innovation. But there's one little interesting twist that I just want to bring up, which is, interestingly enough, that is the same area where the big tech companies all got themselves into hot water with the FTC for no poaching agreements, handshakes that they all had, where they wouldn't hire each other's employees. And it just makes you wonder, did they do that because there was no ability to have non-competes?
Plaintiff lawyers love to talk about California. in this respect, right? If the conversation were homelessness, maybe we wouldn't feel the same way. But in this respect, we do. What about California? It's everyone's answer. And I would only add to that it's always seemed odd to me that we're always putting forth California. No one talks about the legal profession. You have this big, giant profession with big law, and firms aggressively growing and merging, and lawyers moving with their book of business all the time. And we are there is no non-compete because of the ethical ethical rule, which is really about the client, protecting the client's interest in going with whatever counsel she wants. But there's never been a concern expressed that I've heard about, gee, this is terrible. These lawyers are moving big practices. They know the business strategies of the firm. They know the confidential information. That, to me, is as good as the California example of a world in which there are no non-competes and still a vibrant, aggressive, competitive economy.
And let me just throw in a pitch for marginal analysis here. We don't know what California would look like without non-competes, right? California is an amalgamation of very particular conditions, and the question is not, is the sky falling in California? And to my mind, the question is, what would California look like with some non-competes on senior executives or R&D intensive industries? Would you have more investment in R&D than even you do today? I understand the sky wouldn't fall, and same for the legal profession, but the real question for economists or armchair economists like myself is that marginal analysis.
So Taylor, being our resident antitrust expert, and you spoke about this a little bit before, what do you anticipate, or what have been the legal challenges so far to the FTC's power and authority to issue the proposed rule?
Yeah, so I'll try to do this quickly because there are a lot of legal arguments that are going to be raised against the rule if it's promulgated. So the first one is just the plain old statutory authority argument. We heard Ms. Wilkins earlier say that the statutory authority is clear under 6G that the FTC can, Section 6G of the FTC Act, that the FTC can pass rules to help it accomplish its unfairness authority mandate. So the text of 6G says that from time to time, the FTC can classify corporations and make rules or regulations for the purposes of carrying out the provisions of the FTC Act, and the initial provision of the FTC Act that it's referring to is the power to declare and issue cease and desist orders against conduct that is unfair, so unfair competition and unfair or deceptive acts or practices, which is consumer protection type violations. By contrast, there's a provision that allows substantive legislative type rulemaking for consumer protection offenses, and that's in Section 18 of the FTC Act. The text there says, the Commission may prescribe rules which define with specificity acts or practices which are unfair or deceptive acts or practices. That's the term of art for consumer protection offenses. So they can define with specificity acts or practices which are unfair or deceptive acts or practices in or affecting commerce within the meaning of this title. So you see one piece of the text that's referring to administrative, sort of ministerial type regulations that the FTC can pass to help it accomplish its cease and desist order power. And then separately, you see a provision that says you can make definitional rules that are defining what is a consumer protection violation. The glaring silence of that provision around whether they can define rules that are competition violations is really the first and maybe most powerful argument that this authority is not contained in the FTC Act and exceeds what the FTC can do. It can define what is wrong when companies violate the consumer protection provision, but it can't do so. It has to do case-by-case adjudication and issue cease and desist orders when it's worried about infringements on competition violations. So that's the sort of statutory text argument. There's also the question of whether the phrase unfair method of competition even fairly refers to all non-competes. And here what scholars are pointing to is the fact that there's probably the longest record of jurisprudence investigating whether a particular piece of conduct is a violation of the antitrust laws and offends the notions of the rules of competition. The longest history of jurisprudence has to do with employment agreement non-competes. Literally, the seminal cases in antitrust law draw on whether employee non-competes are a problem, and case after case after case throughout the history of antitrust law has said only if they're unreasonable, only if they go broader than they need to for geographic scope, timing scope, if they don't accomplish one of those pro-competitive goals that we were talking about, protecting trade secrets or protecting competitively sensitive information, or the investments that companies are making in training workers and creating goodwill with customers. Those pro-competitive purposes can be advanced by non-competes, but if you have a non-compete that's unreasonable and not looking and tailored to achieve those purposes, then it offends competition. So the FTC here is trying to say, yeah, that's the Sherman Act, but the FTC Act is broader. Unfair method of competition is broader than an antitrust violation. And that's just really breaking new ground. We've never had a court say in a particularized way around a particular piece of conduct that has already been sort of untangled under the antitrust laws. The court has never said, oh, but under the FTC Act, we can go quite a bit further, and all those things that were allowed under the antitrust laws that are really analogous, here we're going to say that they are unfair methods of competition. And maybe even like the most difficult part of this argument is that the FTC itself brought a enforcement action case involving a employment non-compete and arguing that it on its face was an unfair method of competition and should be struck down. And the FTC lost that case in front of the Seventh Circuit. That's Snap-on Tools for anyone taking notes. Snap-on Tools says very, very explicitly that the FTC has to look at whether, under its unfair methods of competition authority, has to look at whether the employment provision is unreasonable in light of geographic and timing restrictions. Now, that's just the Seventh Circuit. Another circuit could split, and we could see this go up to the Supreme Court. But the Supreme Court, as I'm sure everyone in this room is well aware of, is really concerned right now with administrative overreach and the question of whether Congress has sufficiently and clearly delegated a major economic regulation to an agency. And I think Mark was going to talk about that major questions doctrine and how it might map onto this rulemaking.
So Erica,
it is
as our
Erica.
in-house panelist up here, let's talk about the aspect of the rule that touches on retroactivity. So practically speaking, what do you see happening to all of the non-compete agreements that are currently in force if the proposed rule is implemented?
I mean, I think the proposed rule is pretty clear. They all kind of go kaput. They're not there anymore. They're no longer valid. The issue with that is that some of them, could have been in the context of severance, so severance was paid, or in the context of equity, which is very common. So now, someone has received consideration in exchange for the non-compete. The non-compete goes away, but the consideration doesn't. So,
Erica, do you think employers are doing anything differently right now with the proposed rule in the queue, or not just yet?
I think everyone's in a wait-and-see mode. I think hearing Taylor with her long list of things, that could be challenged. I think, and I have heard chatter from different trade associations, like I think the Chamber of Commerce has come out and said that they would, maybe take on some litigation if the rule was put in. So I think people are in a wait-and-see mode. But I will say this, I think, in terms of like what should employers be thinking about, I think they should be thinking about what the laws are right now that we know of. So we know that there are many states with threshold rules. We know that there are states with notice requirements. We know that, you need to show that you really need this non-compete. And that thought process should remain in place. The other thing that I would say is employers should be considering and protecting their confidential information and making sure that employees know that it's confidential information, that they're not supposed to take it if they go somewhere else. And on the flip side, and this is something that I always advise at my companies, make sure that we're telling new employees, we don't want your stuff. Don't come in with that confidential information. We don't want it.
And do you think the battleground is going to shift one way or the other to forensic review of laptops and servers and all that, and looking at the digital footprints of departing employees now? Or is it already, am I a year behind? Are we already there?
Well, I think that's a possibility, but I think administratively, that's not so easy, right? I mean, to have a forensic, look, there are situations where employees do, information gets taken out, or somebody puts something somewhere, without thinking, and puts it in a Dropbox or something, and all of a sudden, hiring a forensic expert to help you get all that stuff back is exorbitant. And administratively, it's difficult. So yes, could you do it? Sure, but you don't want to be in that position on a regular basis.
I just retained an expert for a really rudimentary forensic review in which I learned the old lesson that there is no really rudimentary
No.
forensic review. Sorry.
No, Mark, going back to what Taylor was saying about the major issues and the major questions doctrine of the Supreme Court, what's your take on what we'll be seeing in terms of litigation and questions that go up to the court?
Most of what I know about the major questions doctrine, I've learned from Taylor, and I'll say it at a level of simplicity that you might not be proud of me, Taylor, but it might be better for this audience. We understand that, as Taylor's already suggested, that the current court majority has an antipathy toward administrative agencies, and to say it the best way, they want Congress to make the laws because that's what we elect Congress to do. And even though we elected the president who staffed the administrative agencies, they're not there. They're there to administer, not to make the laws. So it's not a good climate for administrative initiatives. And I just say that, neutrally about the situation. I don't like this talk about the major questions rule, because to me it's like the Second Amendment. Someone just invented it and talks about it like it was always there. There was some serious EPA regs a term ago, and the court said, look, here's a line of cases that says when the agency's weighing in on a major question, the delegation of authority to the agency has to be clear. I'm being a little glib, Taylor, but we'll call that the major questions doctrine, and now that's a behemoth, I would say. I'm prepared to say that regulating non-competes and employment agreements is hardly akin to regulating a climate change from the point of view of regulatory activity, but I think a prong of the major questions doctrine, or the criteria is the agency wading into an area it hasn't before. And it just seems to me that the federalizing of what's been common law issues litigated in state courts in 50 states is a heavy lift.
Yeah, I'll just briefly quote the factors that the Supreme Court cited in striking down those EPA rules. Is it an issue of economic and political significance that will cause major cost increases for companies throughout the economy? Did the agency discover in a long extant statute an unheralded power that is now going to use? Did the agency's discovery allow it to adopt a regulatory program that Congress has conspicuously and repeatedly declined to enact itself? And then that was all quotes from the majority. Then Justice Gorsuch, in concurrence, also points out two other factors where state authority has traditionally predominated and has links to every other economic sector. So to my mind, those are really devastating. That's a devastating laundry list that seems pretty applicable to the non-competes rulemaking.
You got to ask the Amy.
We will accept questions, Sam.
For you,
I want to ask Taylor whether, has this been done before? Has the FTC regulated the internal employment decisions of a single employer before? I know they cited two cases in their
Yeah, so I mentioned.
I looked at those two cases and they didn't support the proposition.
So they absolutely did enter some consent decrees a couple of days before they launched the rule. So those aren't obviously challenged cases where a court affirms the FTC's authority. But there's also that Snap-on Tools case I mentioned that was litigated up to the Seventh Circuit. That was a broader case. There were lots of pieces of conduct that Snap-on Tools was doing, but one of the things they were doing was employment agreement non-competes. But again, the FTC lost they lost on the fact that they hadn't done a thorough enough analysis about reasonableness. So it's definitely difficult from the standpoint of, can you do a per se, these are all illegal rulemaking, or even, call it an unfair method of competition merely because it's a, part of this category. If they had done a more in-depth analysis that is more traditional of the antitrust laws and the cases we see plenty of under the Sherman Act, they very well may have won.
Other questions?
Yeah, so Snap-on, that's like 30 years old, right, that case? So, I mean, this is the problem, I think.
50 now, actually. I think it was 1975.
We live, I mean, this has been an excellent panel, and this is an issue that I have written about and I've also submitted comments on and have done a lot of work on, and I will say, you've really brought a lot to the table and I learned a lot listening from you, so it's been fabulous. There are one or two things I didn't hear, and this is one of them. We can't look at how the Sherman Act was interpreted over 100 years, and the fact that, yes, courts were content to say as long as the agreement is reasonable, then it's not an antitrust issue, because the world has changed and many things are different now. One of the things that's different now is we have HR departments that shoot out these agreements and give them to everybody in their workforce. I appreciate that your clients don't do this, Erica, but I think you'll.
No, I agree. There are companies that do.
Right, so there is an aggregate effect, and then the related piece is that we have the data now. So it was armchair empiricism, freedom of contract that led courts to say, oh, this isn't really a problem. We don't believe that a single agreement is going to impact the economy. But we now have the economic data, that's why the FTC is acting, that says that there are other interests at stake. And I'll just circle it back to sort of an earlier point about, the underlying interests. And I think Erica listed all of the management fear cases where you're not going to be able to use another instrument to address the underlying concern. Guess what? The law says you can't address that concern because that information that can't tangibly be, locked down in an agreement. There's a reason, because we're worried about lock. I don't know if Shlomit is still here, but if you want to analogize to intellectual property law, we have a regime that allows some information to be copied, right? And I think that the historical law here and the reason for the prohibitions, and goes back to the Lynch speaker and so on, to Wilkins and to all of the antitrust conversation we've had before, is because there is this excess space. There is a third party, a public interest concern in these workers moving and this information getting out. And so if employers can't lock this stuff down, they shouldn't be able to.
Well, I guess I would say two things to that. I actually think there's a happy medium to all of this, and we could talk about how you do that procedurally, like maybe it's not through the FTC, maybe it is through Congress, you do it the right way. And I do think that there is a way to sort of make everyone happy, right? I mean, the threshold rules that are coming in from all the states make a lot of sense. Like, there should be threshold rules. I don't think anyone here would disagree with that. I mean, I don't know, maybe someone would, but I think there's some things that could be done that would make this very reasonable. And actually, to be honest, when I work globally, and if you look at sort of what's marketplace in Asia and in parts of Europe, they involve paying people, so they're not losing anything, and they're short. And to me, I actually think that would force employers to use it wisely if they had to pay, and that was the law, and then you could have time limits on it.
I completely agree with you. I'm just going to follow up and say, do it. We need to hear that reasoned voice because from the employer community, because other, of course, the imagine side community, because otherwise the only thing we hear in response on the quote unquote other side of the FTC is the Department of Commerce. And so, this is going to be a problem. Not only are employers on both sides of this issue because they hire, they also have to be really grappling with compliance concerns. There's
Right.
like 14 states with different wage thresholds now.
Yes.
So I think, Amy, it sounds like, organized, maybe the employee side to like put in a comment. I would invite the management bar
Yeah.
to come up with a proposal. The Uniform Law Commission just passed, adopted, that's a model law that doesn't really mean anything. If the management bar was able to come up with a proposal, I don't know, I'm not, in with the FTC, but wouldn't that be a great way of potentially leading to a rule that everybody can live with, and wouldn't we all be better off?
So maybe Roger.
We're working closely with the U.S. Chamber
I think he's up.
Roger King, HR Policy, and we are working closely with the U.S. Chamber and our business coalition. So a couple comments. We're going to win in court. I don't think there's any question about that. If this is going to go forward the way it's presently promulgated. The major questions doctrine and the non-delegation doctrine, I think, are pretty clear on this point, as just articulated. But there's a lot more to this discussion, and the management bar is willing to work on this. But the solution is not through the FTC, it's a legislative solution. And as Mark has mentioned, we have decades of state law jurisprudence in this area that we ought to borrow upon. Florida's a good example, and we can and will do that. But we are also concerned about the precedent this would set. If the FTC can proceed in this fashion, I'm talking the business community perspective, we're concerned about how their jurisprudence may go into other areas that we think are totally inappropriate. The last comment I'd share with you, we think there are unintended consequences here. If you open up this area of no protection for key C-suite people and R&D people, you have the potential to encourage rating on a large scale. So whoever's got the biggest pocketbook is just going to buy the talent and hurt particularly small and medium-sized companies. That's something we don't want to encourage. That's inappropriate competition. So there's a lot of aspects to this, but back to your point, we're willing to work with a sensible, thoughtful solution. And we're not here to defend Jimmy John's non-competes. That's absurd, right?
But Roger, the odd thing now, I've done this for a while, and I've been at CLE panels about non-competes for years and years, and the message is always the same to employers: to make it enforceable, draft it narrowly to your core needs. And yet, I'm constantly running into blunderbuss, overdrafted non-competes, which have caused this problem. If they were shorter and narrower, maybe everyone would be better off, and maybe the management bar has not done what it could to get that message out, and putting us in a kind of rigidified situation all around.
Let me also offer another alternative, which is the FTC genuinely using its enforcement authority to issue cease and desist orders in closer edge cases where it can articulate the real principles of what unfair methods of competition are. We mentioned the 4, I think it may be now up to 5 consent decrees that were dropped, right before and kind of during the rulemaking process. That's a start for sure, and I'm especially encouraged to see the FTC, as Ms. Wilkins talked about at lunch. One of those enforcement actions was against a company where the provision had been struck down in state law, and they were continuing to use it. I mean, that is a core use of FTC authority to essentially litigate on behalf of all the employees who cannot afford to litigate and who will be exploited if it's not for the FTC coming in and using its enforcement authority in an overtly clear area like that. absolutely. Bring more cases like that, show the boundaries, articulate positions like 2 years is the maximum that we ever see in X labor market, right? No, the turnover, even in tech, even in Silicon Valley, is fast enough that in Silicon Valley type organizations, maybe it's even faster than 2 years. Articulate these principles in enforcement actions, and guess what? The bar is listening to those, and that's absolutely how competition cases in other areas have proceeded. And I'm an antitrust lawyer who gives that advice to companies how to comply with that law as developed in common law all the time.
Is there a role here for state law enforcement? Because
Yes.
this has been the law. I was the chief reporter of the restatement of employment law. We have a provision in the public policy that is a tort when you're trying to enforce an unenforceable covenant. Are the states' attorney generals getting into this area? Because there's authority for them to enforce these kinds of provisions. Almost every state treats them as presumptively unenforceable. And we might disagree at the margin, but I don't know why it wasn't FTC rule here, frankly, but are the states in this area enforcing it?
Well, one of the problems is it's creating just this huge patchwork quilt. So you've got, in this state, it's this
Well, even the
threshold,
state
in this state,
unemployment
it's
law,
another.
it's
So.
not patchwork. There are a couple of variations,
No,
but by and large, the rules are, you have to protect trade secrets, it's gotta be limited time. And 1 year is like, when I advise clients, it's over 1 year.
Yeah.
I say, you're not gonna get it enforced, and it's a public policy tort. Mark, why aren't you bringing some of these public policy torts?
I'm not, I don't have any confidence that that's going to be successful here. Maybe I should bring it anyway. But I don't, honestly, Sam, if someone comes to me with a 2-year restriction, I can't say to the executive, don't worry, that's unenforceable. And really, the reality of it is, the last time I had a 2-year restriction that we took to court, it was blue penciled. It was blue penciled down, and my guy worked from his kitchen for 1.5 years.
Well, blue pencil may need to be regulated. It has to be, again, there are restrictions on the blue pencil as well. It's not
I hope the FTC's initiative here might cause state courts to look at this a little more vigorously. Certainly where lower paid people are involved. That's what I, and I hope that Erica's her company, their concern about an antitrust action from the FTC will cause them to. I'm sure they write them narrowly now. Will cause employers to write narrowly that will go downstream and help my clients who come in.
Okay, we are beyond our time.
Be on this panel with you guys.
Wait for Allison, folks.
Okay.
Yeah, this is so fun. I'm so glad.
Yeah, great job.
Thank you. Thank you so much. I am aware that there is an event here tonight, and we have a reception on the 3rd floor in the faculty library for you. So we encourage you to do your talking and your photo taking up there, and to go enjoy it. And thank you for your time.